So, good evening. My name's James. I am one of the program coordinators at the Kentucky Historical Society. Welcome to our Constitution Day virtual speaker. So, yesterday was Constitution Day, which marked the 238th anniversary of the signing of the U.S. Constitution. This set up the framework for what our government can and cannot do, and is the foundation of a lot of our government's principles and the way that it works. Because we have a system of federalism, we have both state constitutions and national constitutions. And Kentucky has had four different constitutions since its statehood in 1792. Uh, so tonight's speaker is Denis Fleming Jr., and he'll be discussing Kentucky's early political history and the influence of Thomas Jefferson on Kentucky's Constitution. Fleming's a graduate of the University of Kentucky's College of Law and has worked with various politicians in the following years. He'll be discussing content from his research and his new book, Thomas Jefferson in the Kentucky Constitution. So, if you have any questions, there is a question and answer tab that you can click and ask your questions, and we will get to them after his presentation. So with that, I'll turn it over to tonight's speaker, Denis Fleming Jr.
James, thank you very much. And thanks to the Kentucky Historical Society for sort of sponsoring this chat. And thanks to those of you that are tuned in that are interested in the book. Hope you've had a chance to read it or perhaps get it. If you haven't, maybe you'll get it and enjoy it. So, Thomas Jefferson and the Kentucky Constitution. We're going to chat mostly here about Jefferson's influence that I sort of discovered, I think, through the papers of George Nicholas that are housed up at the University of Chicago on Kentucky's Constitution. But listening to James's introduction about the federal Constitution and the fact that yesterday was the 238th anniversary of the signing of the federal Constitution, one of the things we'll touch on here in just a minute is the role that George Nicholas played, who was sort of the person that was the lead on Kentucky's Constitution in 1792 at that Danville Convention. Before he came to Kentucky, he was sort of the floor general for James Madison at the Virginia Federal Constitutional Ratification Convention in Richmond. You know, what happened there at the federal level in Philadelphia in 1787 was terrific and certainly worth celebrating, but it wouldn't have amounted to much if you couldn't get the states to ratify it. It required 9 of 13 states to ratify it. And the big one they were going after was Virginia. And we'll touch in just a moment on George Nicholas's role in that, but it just sort of came to mind, James, listening to your introduction. But it was sort of the launching pad for his association with Kentucky, and it motivated him to come to Kentucky and get involved in our Constitution, where he sort of channeled the thinking and the things that he'd learned about state constitutions from Thomas Jefferson. So Thomas Jefferson, let's put him up here. I think if you'd asked me before I wrote this book what I could tell you about Thomas Jefferson, I probably could have remembered that he wrote the Declaration of Independence, which he did in 1776 when he was a young man. I think he was 35 or 36. And I'm sure I could have remembered that he was president, but he did a number of other things. He had a lot of other positions and he had a number of interests. He was really interested in tinkering with constitutional provisions at the state and federal level. He was interested in statutes. He was interested in writing. He wrote one of the longest books he wrote was Notes on the State of Virginia that George Nicholas drew on to work on Kentucky's Constitution. I think he wrote an annotated Bible of some sort. He wrote a book on parliamentary procedure when he was vice president under John Adams, but he was really interested lifelong in this notion of separation of powers and how you can properly draw a line or barrier between the different branches of government, the executive, legislative, and judicial branches. Nowadays, it's sort of odd to look back on it and think, why were they so fascinated with that? But we've got to put ourselves in their shoes as founders, just coming off a difficult revolution for 7 years that they fought. Jefferson himself was sort of run out of Monticello by the British right at the end of the Revolutionary War when Cornwallis and Banastre Tarleton were sort of trying to chase the Americans out of Virginia. George Nicholas himself fought at the Battle of Brandywine, and it was a very difficult period. So they wanted to make sure they didn't go back to a situation in which you had an overactive executive branch, for example, and they wanted to make sure the judiciary was independent. So these were things that Jefferson was really concerned about, and he passed on these interests and concerns to George Nicholas and John Breckinridge, who were the principal authors of our first two constitutions in 1792 and 1799. So let's take Jefferson back, sort of back up from when he was president. We'll back into George Nicholas and John Breckinridge. Uh, Jefferson was president for two terms, 1801 to 1809. A lot happened there. Louisiana Purchase. John Breckinridge by then was a senator and worked closely with him, and attorney general just before he passed away. But before that, he was vice president under John Adams. That's where he got wrapped up in the Alien and Sedition Acts. He secretly authored the Kentucky resolutions in opposition to that law. If you can believe it, he and Adams didn't get along. We always got to remember the electoral system back then, for example, under Adams and Jefferson, was different. We didn't have a slating requirement. So they sort of butted heads on a lot of things politically and philosophically, and particularly in terms of international affairs. But continuing to go back from Jefferson, he was Secretary of State under George Washington. And before that, he was Minister to France for 2.5 years. But the thing I don't think I could have remembered is that he was governor of Virginia for 2 years. He served two one-year terms, 1779 to 1781. And that's where he ran across George Nicholas and John Breckinridge. They were young men elected to the Virginia House of Delegates. Breckinridge got elected from Staunton, Virginia, when he was 20 years old. Nicholas was 24 years old. And where I first came across Nicholas and Breckinridge is this little story to the right. It's an excerpt from an 1898 Kentucky Supreme Court opinion. And to the left there, I have Jefferson. Now, there's a purpose for that portrait of Jefferson. It was his daughter's favorite portrait of him. Martha Jefferson Randolph thought that was the best likeness of him, next to the Houdon sculpture that was done in France in 1789. And you can see Jefferson's red hair there. But it's particularly important because that's the same year where this meeting described on the right, in this case, allegedly took place. Now, where I came across this story, when I was in Frankfort as general counsel to Governor Patton, we'd been there about 6 months, and we were running into some difficulties that we argued about politely in the court between the executive and legislative branches in terms of the governor's ability to promulgate administrative regulations. It turned out this is something that's been going on for about 50 or 60 years. And we felt like we were headed to court over a challenge that the legislature was presenting to the governor's office. And we retained Cheryl Snyder. Cheryl Snyder wrote the foreword to my book. And he came by one day and he had represented Governor Brown with Burt Combs in the famous case of LRC versus Brown, which was a landmark case back in 1984 that sort of drew some distinctions between the ability of the legislature in interim sessions between budget years to attach or essentially veto administrative regulations. But Cheryl brought me an article, or a law journal article that he wrote in 1984. And it was on the state constitution, separation of powers. And I read it, and that article said, buried deep within it, that Thomas Jefferson wrote the first two clauses of our first, second, and third constitution. 1792, which George Nicholas was the principal author of, 1799, which Breckinridge was heavily involved in, 1850, where there's some significant revisions, and it remained in Kentucky's Constitution to this day as sections 27 and 28. Now, those clauses are unique. They're short, but we're the only state that has this bifurcated form of separation of powers clauses. They're not in the federal Constitution, and we'll mention in a minute how Jefferson tried but failed to get them in the federal Constitution. He felt so strongly about it. So these clauses are important for a couple of reasons. One, they have been used repeatedly by the Kentucky Supreme Court and some of the inferior courts and the Court of Appeals to justify some of the greatest public policy reforms Kentucky has ever had. Bob Stevens, in particular, used them quite often in his 20 years on the bench on the Supreme Court and as Chief Justice. The education case, the Rose education case, for example, comes to mind in 1989. is where the clauses were used. It's been used in budget cases. It's been used in cases where the court felt the governor's office was going too far. For example, when Governor Fletcher tried to issue a budget through executive order when the legislature failed to act. Over and over, these clauses have been deployed and used offensively and defensively. But what's interesting about them is that the Court of Appeals and the Kentucky Supreme Court in the last 25 years have begun to question whether Jefferson had anything to do with these clauses at all. Justice Cooper in the Fletcher budget case in a footnote said we're using these clauses again and saying that Jefferson wrote that we've never seen any indication or evidence that he had any influence on these clauses. And fast forward to a case that is alive and well today. It's on appeal right now, the Kentucky Supreme Court, Shell versus Bashir. It's a case in which the legislature passed a law giving the Commissioner of Agriculture the ability to appoint ex officio members to the Kentucky State Fair Board was challenged as being violative of the separation of powers clauses. Also turned on a couple of other clauses in the Constitution, Section 69 and 81, dealing with executive powers. But these clauses were used again, and the Court of Appeals, in a 2-1 decision, upheld their use and said that the legislature had exceeded its authority. But there was a significant dissent to that case of nearly 200 pages that in several places said that Jefferson had no influence or involvement in these clauses. Said that his influence actually didn't exist and was a hoax, and that George Nicholas had no particularly identification or influence on any separation of powers clause. So when that came out, I had just stumbled across the papers of George Nicholas at the University of Chicago. We'll chat about this just in a minute, but I think these go a long way to demonstrating that Nicholas was very much mindful of Jefferson's thoughts on separation of powers and deployed them. So let's move on here. There's myself with Cheryl Snyder. We're in court in Franklin Circuit Court many years ago in 2001 on a budget case, and we were actually using Jefferson's clauses there. I'll go back to this story real quick here. In the article of Cheryl Snyder, I looked at it a few years ago, and he had a footnote to this case. This is a dissent from the case that tells the historical context of Jefferson meeting with John Breckinridge and George Nicholas in 1792 at Monticello outside of Charlottesville, and that Jefferson actually wrote them these clauses and went on to say that Jefferson drew the form of the provision, gave it to Nicholas and Breckinridge. And one of the reasons for that was that Jefferson felt that the branches of government in the federal system were not protected each from the other. So I began to wonder if this actually happened, if there was anything to it. And I think the real magic in trying to demonstrate Jefferson's influence comes about through a study of George Nicholas, his career, and particularly his papers, where I ran across repeated references in his own handwriting to Jefferson and his involvement in writing Kentucky's first Constitution. This is a picture of William Carey Nicholas. For the life of me, I couldn't find a good picture of George Nicholas. There were some caricatures apparently at the time made of him, but I could never find him. I found one old picture of him that was 30 years after he passed away. It was a drawing, and he had a lot of hair, and I was suspicious of that because when I read a lot of the contemporary accounts, everyone said he looked very much like his brother. This is a Gilbert Stuart portrait of William Carey Nicholas, who was Nicholas's younger brother. And he went on to have a distinguished career as governor of Virginia and United States senator. But Nicholas was born in Williamsburg, Virginia. He was an attorney. His father was an attorney. His uncle was a member of the Virginia House of Burgesses. He married a young lady from Baltimore. He served in the Revolutionary War. Apparently, he saw some action, I think, at the Battle of Brandywine, but he sort of incubated there in the Williamsburg, Albemarle area and studied law at William and Mary. Now, one of the first links, I think, between Nicholas and Jefferson I came across was at the College of William and Mary, where George Nicholas studied under uh, George Wythe. Wythe was the preeminent legal scholar of his day, and Jefferson was very fond of him. Jefferson studied under Wythe himself, when he wrote his autobiography later in life for his family a few years before he passed away, he starts out mentioning the importance of George Wythe in his life as probably his greatest mentor. And not only did Nicholas study under Wythe, John Breckinridge studied law under him. John Marshall, who went on to be our first Supreme Court justice, and Henry Clay from right there in Lexington. Henry Clay was one of his last students. Wythe lived on into his early 80s. But Nicholas became interested in politics, I'm sure at the behest of his father and perhaps his uncle, or maybe with the encouragement of Jefferson. I sort of try to speculate in the book that they may have run across each other at this point. But one thing's for sure, when Nicholas ran for the Virginia House of Delegates and got elected in 24, I was interested to see that within 6 months of his election, he decided to move to Charlottesville, Virginia, and bought a house, a large house, took his family with him. He ended up having 8 kids and his wife, and it was 3.5 miles from Monticello. So, of all the places Nicholas could have moved, he could have moved to Staunton, which is a bustling community in the western part of Virginia, where John Breckinridge was from. He could have moved to Richmond. He could have moved to the capital. He could have just stayed in Williamsburg, but he chose to move to Charlottesville. And I began to see him sort of live and incubate in the legal and political environment there in central Virginia, in the Richmond area. He worked on criminal justice reform with John Breckinridge. Breckinridge had just gotten himself elected in the same year in 1779 to the Virginia House of Delegates at the age of 20. If you can believe it, he actually violated the Virginia Constitution. I start off mentioning that in the book, but they let it slide because he was 21 when he was sworn into office. Both of these fellows, with Jefferson and with others like Patrick Henry, Daniel Boone, if you can believe it, they became a part of a society called the Virginia Constitutional Society. They only had 3 meetings, but they were working on ways to change the mechanics of Virginia's constitution and bring it up to speed. Jefferson was really focused on how to keep Virginia's Constitution current and revised, and he was constantly tinkering and working on drafts of the Constitution. But where Nicholas really decided, it came, I think, into the fore and became very prominent was his role at the Virginia Ratification Convention in Richmond, Virginia in 1788. What happened in Philadelphia, as I just mentioned, was important. But if you could not get the states to ratify the Constitution, the country was in trouble. It wasn't in trouble, but it was probably going to revert back to the Articles of Confederation, or more of a balkanization of the states and perhaps the southern states having their own confederation as opposed to the northern states. And we'll see in a moment that the real nemesis of James Madison and Nicholas was Patrick Henry, who they overcame at this ratification convention. But I began to see a lot of correspondence between Madison and Nicholas, where Madison was essentially designating Nicholas to be the floor general for the main debate in Richmond at the Constitutional Ratification Convention. Virginia was critical because it was the largest state in terms of land area, West Virginia and Kentucky. It was called the Kentucky District, was included within Virginia. Kentucky sent 14 delegates to this convention out of 170, but they became absolutely critical to trying to get the Constitution over the top. Virginia was also the economic engine of the colonies, from an agricultural base, and it was the largest in terms of population, and most of the founders were from Virginia. So with Washington at Mount Vernon, when this convention started on June 2nd of 1788, Jefferson was overseas as minister to France. It was left to Madison, who was one of the architects of the Constitution just several months before in Philadelphia, who came up with the Virginia Plan and some of the other major structural things that made it into our first Constitution. He was the architect of the strategy, but he picked out George Nicholas, and Nicholas is one of the most underrated, underappreciated persons I've ever come across in Kentucky history, because he really came into his own there at the age of 34 at this convention in Richmond and took on Patrick Henry, who at the time was 55, had been governor of Virginia, and was very famous as a national icon, give me liberty or give me death. His speech at that Episcopal church there in Richmond, calling for armed conflict, with the British. Nicholas was a very young man, and I can see in the transcripts of the debates that he began to get more and more brave and bold and started to take on Henry. But it was a very difficult battle for 3 weeks. Twice a week for 3 weeks, Madison would write George Washington at Mount Vernon, and he would say, Madison became ill. I think if you ever read Lynn Cheney's biography of Madison, she, from contemporary accounts, concludes that he probably had a form of epilepsy and he had some intestinal disorders, and he missed several days the first week of that convention. And he would write Washington and say, I've got to count on Nicholas. Nicholas is my best debater. Uh, he is uh, he is the best vote counter that I have. He thought he was the one that could really figure it out, and he said, "Nicholas tells me it's dead even. It's 80-80, and the whole thing's going to turn on the Kentucky delegation." And Washington wrote him back and said, "Oh my God, we've got to get this resolved." I'll move on through a couple of the slides. That's the only portrait that I could come across of John Breckinridge, by the way. There on the left, that hangs Department of Justice in D.C. But here's an excerpt from George Nicholas's speech at the penultimate moment there at the Virginia Ratification Convention. This was on the last day. Nicholas had gone back and forth with the Kentucky delegation. Kentucky was right on the fence. He was able at the last moment to peel off 4 of the 14 votes from Kentucky and convince them to vote to ratify the Constitution. Why was Kentucky so difficult? Kentucky, as many of you may know, had tried since 1784 to get its act together with the Constitution. And through a combination of internal dissension and a good deal of distrust, I think, of the federal government, there were concerns that the federal government had not done enough to protect the frontier of Kentucky from Native American incursions. There were a number of battles where Washington had to deploy troops up in Northwest Ohio and Indiana and Illinois. But they were particularly worried in Kentucky about the right of navigation on the Mississippi River. Mississippi was critical in the port of New Orleans in terms of our export and import trade through central Kentucky, up through Limestone Creek, down the Ohio and down the Mississippi to New Orleans. And the United States fledgling country through John Jay, who was our titular Secretary of State at the time, had signed a treaty that was defeated barely in the Senate that would have given Spain the right of navigation and control over the port of New Orleans for 25 years in exchange for money and some other concessions that we were going to get. And this made Kentucky very suspicious. So a lot of the convention was trying to convince just these Kentucky delegates, if you could just peel off enough of them, you could get the federal Constitution approved. This is an excerpt from Nicholas's speech there. Kentucky can expect support alone from a strong, efficient government which can command the resources of the, I think, federal government when necessary. That country, he called it, Kentucky, contains all my wishes and prospects. There is my property, and there I intend to reside. This union will secure Kentucky's happiness and liberty. So there is George Nicholas, who in a few months moves to Kentucky to work on our first Constitution, announcing to the convention on the last day when they're about to have the vote that he is not about to vote for something that's going to hurt his economic interests. He had already begun to buy, sight unseen, a lot of property in Kentucky. I tend to think John Breckinridge might have had some influence on him. John Breckinridge had already made 3 trips to Kentucky at this point. He made several more. He had his mother-in-law and his 2 half brothers were in Kentucky. But Nicholas was bound and determined to get Kentucky. I found him a little more entrepreneurial and interested in agricultural pursuits, I think, perhaps than John Breckinridge. But the upshot of this, at the end of this speech, who does George Nicholas roll out to make the concluding argument at the Virginia Ratification Convention? It's George Wythe. He's 67 years old. Madison is there. They introduce Wythe. They have the vote. It's 89-79, and the federal Constitution is approved. So Madison's exhausted. He's collapsed a couple of times. George Washington writes him a letter and says, "You told me you're sick. You need to come to Mount Vernon and spend a few days with me." Madison goes to Mount Vernon July 4th through July 7th and then heads up to New York to try to work on that convention. But Nicholas, within a few weeks, starts writing a series of documents trying to get ready to go to Kentucky and help Kentucky with their constitution. And he, I began to see letters from Nicholas. This is not one of them, but I'll get to this in a moment. This is a fairly important document. Nicholas writes Madison within a few weeks of the Constitutional Ratification Convention in Richmond and says, I'm headed to Kentucky. They want me to work on their Constitution. Do you have any ideas? He says, I'm working from Jefferson's notes on the state of Virginia, which was a key. That was a big deal to me because that sort of made me want to go look at what is in the notes in the state of Virginia that Jefferson may have said about Virginia's constitution that Nicholas would use. But Nicholas begins to write and write and write, and he has hundreds of pages of papers that I came across up at the University of Chicago. But I thought I had a pretty good book before I came across these papers. And when I stumbled across them one night, looking around on the internet and found links to the George Nicholas papers, the University of Chicago, I was astounded. These are a series of pages of papers. There are 36 boxes of them and hundreds of pages, mostly all in the handwriting of George Nicholas. They were collected by Reuben Durrett, who was one of the founders of the Filson Historical Society in Louisville. In the late 1880s, he went around Kentucky collecting historical papers. Somehow he got his hands on the papers of George Nicholas. Decades went by. He had a stroke, managed to survive it a little bit. He and his family tried to sell the papers to a university. They sold them for $28,000 to the University of Chicago, and they've been up there. And as far as I've seen, they've only been cited a few times. Lowell Harrison, the famous Kentucky historian, referenced them in an essay on enslavement and a history of the Kentucky Constitution he wrote about 35 years ago. And there's a scholar at Texas, University of Texas, that utilized some excerpts from them, but I was never able to see anyone that came across these references that I'm about to demonstrate to you, where Nicholas, in his own handwriting, and Madison are referencing Thomas Jefferson. Now, before I get to that, this page, it was not included in the book. I thought about putting it in there, and it's entitled "To the Citizens of Kentucky." It's in Nicholas's handwriting. One of the reasons I didn't put it in the book, because I didn't have enough space for it. It's difficult to read, and it doesn't have a date on it, but it's a box of material that's related to the convention. I think it's Nicholas's opening remarks. I think it's a draft of his speech at the Kentucky Convention. But what's interesting about it is, look in two places here. Here he is talking about freedoms and liberty and justice and so forth. But what does he mention twice within the first three paragraphs of the speech is separation of powers. The people are now free. Let them by solemn and deliberate act delegate such powers to the three departments as are necessary for the preservation of their rights and happiness, and retain all other in their own hands. At the end, let the Constitution therefore limit their power, assign each department its appropriate duty, and prevent either from infringing upon the rights of the people or invading the province of the others. I thought, my God, there it is right there. That is, here we are, the Kentucky Historical Society. That's the start of Kentucky right there. And what is he talking about is this business of separation of powers. But it doesn't end there. I went on and started to scroll through the papers, and I noticed this handwriting, which is different from Nicholas's. And there's Nicholas writing some interlineations and hash marks that I theorized he probably used in a speech. And at the bottom, you see a reference in fairly small handwriting to Jefferson 195. This is all an essay on separation of powers, and I'll show you the translation of it here in a moment. But I wrote the University of Chicago, and I said, do you have any idea what Jefferson's doing here? I think he's talking about separation of powers, and I think he's somebody that's really influencing what Nicholas is doing at the Kentucky Constitutional Convention. I said, what are these numbers? And it took a couple of weeks, and I said, I'd like to use this in my book. And they said, well, you asked for permission, and we'll be glad to do it. And how would you use it? So I wrote about 7 or 8 pages of an early chapter. And they finally got back to me, and they said, well, these references are to Jefferson, but they're citations to pages from Jefferson's notes on the state of Virginia. And I said, well, how do we know that? They said, well, because the original edition of Jefferson's notes on the state of Virginia, the 1787 and 88 editions, from London and Philadelphia are both in his papers. I said, well, can you send me? So they sent me that page, and there's a reproduction of the page of 195, and it is right in dead center of a 21-page essay that Thomas Jefferson wrote in his book Notes on the State of Virginia about separation of powers and the need to make sure there are proper barriers in a state constitution and delineations between the branches of government. That essay is essentially a history of Virginia's constitution, from the flawed Constitution under the House of Burgesses through the 1776 Constitution and changes they had later on. But that wasn't the end of it. I kept looking through and I noticed this handwriting, which was similar to that of the other. And I ran all this by the Jefferson experts at the Princeton University, where a number of his papers are held. And they said it's almost a certainty this is the handwriting of Madison. I think this is part of the reply from Madison to Nicholas in his inquiry for help, because it's part of an 83-page essay on notions of what he thinks should be in Kentucky's Constitution. It's about courts and separation of powers, and he repeatedly uses Jefferson's name at the bottom. Sometimes he has a number. This is Breckinridge's handwriting, Jefferson 126.7.3. I got stumped on that, and I said, well, this is a different number, and I can't find anything in the earlier edition that you sent of the Notes in the State of Virginia that reflect this. And they said, oh, that's just the other edition. What he's doing here is restating word for word what Madison had written to him about the need for separation of powers between the branches of government, and referencing Jefferson's writings from the later edition. And here is some more. There's Jefferson again at the bottom. This is an essay on separation of powers. He talks about the courts. They need to be independent. What happens if we have an overactive executive? The need for term limits. We don't want to go back the way it was in Great Britain. We don't want to have a judiciary that's controlled by the House of Commons or by the king. It's amazing today to think about how important they thought these things were. And here is sort of a translation of that first item that was in Madison's handwriting. But by separating them, the legislator, TOR, will not pass an improper act because another is to execute it and he is to be subject to it. The executive dare not act oppressively under it as another, which is the judiciary, is to judge his conduct, and the judge will declare an unconstitutional law void and punish the executive office for his tyranny. The independence of the judiciary, I can't tell you how important that issue was back in Kentucky. There was a run at the 1799 convention by Alexander Bullitt and some other members from Jefferson County to give the General Assembly a veto power over any legislative decision. And the roots of all these problems were property disputes back then, where some folks in Kentucky were concerned that property that had been granted to them by folks in Virginia were being challenged, and they were being, relieved of their rights to their property. So it was a big deal. Such a government where powers are mixed possessed also the advantages and is clear of the evils of a monarchy. The monarchy is a big deal. They're worried about, fighting that war and then going back to where we're going to have an executive branch that's too powerful. By dividing the power into different hands, you are certain that one of them will oppose any improper step of the other. Jefferson 195, reference to his. And here's another interesting excerpt. Thus, the legislature cannot transfer to themselves any of the branches of the executive powers. He just goes on and on. I can't tell you how many essays there are. This is in there to show you that is Nicholas's handwriting. That's a signed letter that he wrote in his papers to Madison. So what's the product of all this? In Danville. This is the cover of the original Constitution that was printed in Lexington by John Bradford. John Bradford was the publisher of the Kentucky Gazette, and you can see it's dated down at the bottom, 1792. It's in June of that year. And there it is. Those are the first two articles that Nicholas put in there on separation of powers. I think almost certainly at the behest of Jefferson and probably influenced as well by Madison, both of whom were his mentors. There's the first article. It says the powers of government. That's sort of a conflation of the first three articles of the federal Constitution. Powers of the government are divided into executive, legislative, judicial branches. And there's the interesting one. Under Section 2, no person or collection of persons being of one of these departments shall exercise any power properly belonging to either the other, except in the instances hereinafter expressly permitted. That covers, I think, instances of impeachment and the veto power and some other items like that. So, what does all this mean? It's certainly some interesting history, but this tension between the branches of government is constant and ongoing. And here are the example of a couple of cases that have just come down from the U.S. Supreme Court recently. And the thinking is, I wonder if a separation of powers clause in the federal Constitution, as Jefferson preferred, would have made a difference. It certainly has made a difference in Kentucky. Jefferson and Nicholas, in some of his essays in those papers, talk about how the judiciary can use these clauses to protect one branch from the other. And Jefferson tried to put these clauses in the federal Constitution. We know that because if you go and look at the Federalist Papers, Federalist Essays number 47 and 48, which Madison wrote, he spends 6.5 pages and mentions Jefferson by name and says we don't need these clauses in the federal Constitution. He called them mere words on parchment. He didn't think it mattered. Jefferson thought it mattered, obviously, and so did Kentucky's founders. And what's interesting is those clauses have been used over and over. Now, would they have made a difference nowadays? It's hard to know. These two cases, Loper Bright and Jercasey, are huge cases. Loper Bright is a case that just came down maybe 8 or 9 months ago. It reversed 40 years of case law and it did away with what's called Chevron deference. That was a case that said the judiciary should defer in rulemaking to the judgment of executive branch agencies. And the court turned back 42 years of case law and said the judiciary should exercise their own independent judgment. This Jercasey case is a huge case that invalidated the SEC's adjudicatory process on the grounds that it invades the province of the federal court system under Article 3. And it said there's no statutory basis for that. So the court is going back and dealing with what they constantly see as intrusions upon one branch upon the other. And then finally, I'll mention Shell versus Bashir. I brought that up earlier, but that's a case right now on appeal before the Kentucky Supreme Court. And it'll be really interesting to see how that case comes out because these clauses are alive and well and used in that context. And I think the briefs have just been submitted and the oral argument was set, I believe, 2 days ago. It's going to be held in the courtroom at the University of Kentucky, Rosenberg College of Law on October 15th. So moving on, this deals with the Alien and Sedition Acts. Now, these are 3 chapters in the middle of the book, and the purpose of the chapters was to show continuity between John Breckinridge, George Nicholas, and Thomas Jefferson. The Alien and Sedition Acts were a big deal at their time. Now, when I wrote these chapters, I had no idea the Alien and Sedition Acts, and in particular the Alien Enemies Act, which is a portion of that law, would be alive and well. That is what has been used by the current by the Trump administration for their deportation scheme, the provision of that law that allows for the deportation of alien enemies that have engaged in predatory incursions or invasions. And predatory incursions is sort of what is the operative language. It's been declared unconstitutional, the use of the acts by 2 of the lower courts, a district court in Texas and the Federal Court of Appeals in New Orleans, and it's on its way to the Supreme Court. So this is a bit of history that's absolutely fascinating and has current day relevance. But back in 1798 and 1799 and in Kentucky, it was a big deal. The Alien Enemies Act were passed by Congress in 1798 by Congress at the request of President Adams, largely in reaction to a developing war in France that was known as the Quasi War. We began to have some of our merchant shipping and our naval vessels attacked in the Caribbean by the French. We had begun to have some difficulties with the French. We had signed a treaty, the Jay Treaty, that gave us certain rights of navigation on the high seas that the French didn't like. The Bourbon dynasty had left. We owed France a lot of money. The United States budget was about $27 million that year, and we owed the French $3.5 million. And they were demanding payment. And we sent a delegation over to France. John Marshall was one of them, the future Chief Justice, in an effort to negotiate what was then the developing French Empire, and with Talleyrand and some others, try to negotiate a better payment. And before we could even meet with them, our delegation was asked for a $1 million bribe, which nobody had. And we didn't have the authority to pay the bribe in addition to what France thought we also owed them. So our delegation came back, told John Adams our ships began to be under greater attack in the Caribbean, which was a big deal. Remember, the port of New Orleans was critical to Kentucky and to, the mercantile exchange going on there in the central part of the developing United States, and what later became the Louisiana Purchase that we purchased from France. But Adams quickly put the country on a war footing. He passed a national property tax, if you can believe it. There were riots all over the country against that. There was Fry's Rebellion in Pennsylvania. The farmers went up in arms and refused to pay the property tax. And some farmers broke into the jail and attacked the federal marshals, let the farmers out. It was the biggest mess you've ever seen. Adams later pardoned them all. But that was the sort of environment we had going on in the country. They were trying to raise a 20,000 person army, a capital shipbuilding program, and the Alien and Sedition Acts were passed. That law criminalized criticism of the president, which Jefferson particularly disliked. It called for increasing the amount of time to be an American citizen from 5 to 14 years, but it also included the deportation scheme and the Alien Enemies Act. Kentucky had a fit over it. Kentucky, and I was amazed at, I've tried to figure out why was this, because there were protests all over Kentucky against the Alien Enemies Act and the Alien Sedition Acts. And when I began to look at the Kentucky Gazette, which you can find there in the Lexington Public Library, I came across, first of all, it was interesting. Every edition, at first it was twice a month and it was once a week. There was a front page column, the news from France. And I began to wonder, why was everybody so fascinated about France in Kentucky and central Kentucky? But when you look at the place names in Kentucky that developed at that time, uh, Fayette County is named after Lafayette, Bourbon County, the Bourbon dynasty. The county seat of Bourbon County is Paris. LaGrange in Louisville is named after Lafayette's estate. Louisville, named after Louis the 16th. There was a great affinity for the French and the French government. And the Scotch Irish were viewed as being associated with the French. So people in Kentucky took a lot of umbrage to this. And there was actually a rally turned into a bit of a riot. And it's hard to see, but it's down there in the lower right of that second column from the left. You can see Lexington. That's a story on the second page of the Kentucky Gazette. I think it was around August 16th of 1798, about a rally that 5,000 people attended. And I looked at the census population of Fayette County in 1800, and it was only 14,000 people. So anytime you can turn 5,000 people out at a rally, it's a big deal. George Nicholas spoke. Henry Clay spoke and got in a fight. He was a 23-year-old legal intern in John Breckinridge's office. I couldn't find any evidence that Breckinridge attended, but he probably was there. Nicholas gave a big speech, for the last speeches he gave, because he passed away about 8 months later. But the entire area of Kentucky was up in arms. And what Jefferson saw, I believe, was an opportunity to work with his old proteges, Nicholas and Breckinridge. And what Jefferson wrote were the Kentucky resolutions. He did this secretly and used Wilson Cary Nicholas, the brother of George Nicholas, as the conduit for these resolutions. And there's some evidence in Dumas Malone's biography of Jefferson that Nicholas and Breckinridge actually went to Monticello and met with him on these resolutions. Anyway, they were passed in the Kentucky General Assembly. Kentucky refused to enforce the Alien and Sedition Acts. Jefferson later regretted it late in life. I mentioned this in the book. Breckinridge's grandson wrote him a letter about 2 years before Jefferson passed away, and he said, "Hey, I've always been interested. Did you actually write those Kentucky resolutions for my grandfather?" And he said, "I have to tell." He said, "It's important that you know the truth. I actually did it." And I think he was always a little embarrassed about it because it was, very disruptive at the time. But I think it was heartfelt, and the same thing was passed in Virginia by Madison. Other states opposed it. New Hampshire thought Kentucky was being traitorous. But in any event, the Alien Sedition Act sort of died a slow death. They were a big factor in the 1800 election. They were never really enforced. Kentucky passed its nullification statutes. We passed two versions. We passed another version in 1799. And I make the case in the book that the Alien Sedition Acts and all that uproar uh, played a critical role in the election of 1800, where Jefferson defeated Adams and became president. And within a few years, he began the process of trying to negotiate the Louisiana Purchase, for whom John Breckinridge of Kentucky, by then a United States Senator, was the lead person on the floor of the United States Senate, putting together this package and getting that accomplished, which, by the way, Jefferson worried himself to death about. And there are records in the Breckinridge papers where Jefferson wrote Breckinridge and said, I'm worried this is unconstitutional. We can't bring a territory into the United States. There's only provision in the Constitution to bring a state into the fold. And he said, just don't worry about it. We've got the money. Let's let the Senate pass it. It's a fascinating exchange of letters, but ultimately, I think all of this played a critical role in allowing the nation to make the Louisiana Purchase, bring in about 15 million acres and what amounted to another 14 or 15 states. And Breckinridge continued to play a key role in that. Breckinridge went on to be, at Jefferson's request, the United States Attorney General. There was some discussion about him being a vice presidential or even a presidential candidate. And unfortunately, in 1806, he passed away of what they believed. James Clotter, the historian, in his book on the Breckinridges, believed was tuberculosis. I look back, there was a lot of accounts of a tuberculosis epidemic at that time in central Kentucky. He did his best to get back to D.C. to help Jefferson with a number of items that were hot on the griddle for him legislatively, but he couldn't make it. And Nicholas happened to pass away within 4 days of the last speech he ever gave at the 1799 Kentucky Constitutional Convention, right here in this Capitol, right there on the screen. That was one of two capitals that burned to the ground. This one burned, I think, in 1813. The next one burned in 1828 or so. And then the stone capitol that's there now, before the 1910 Capitol was built. But this was the site of the 1799 Kentucky Constitutional Convention that did a number of good things. It actually also considered enslavement. There was a strong effort to abolish slavery. It was hotly debated at the 1799 Constitutional Convention. We added a lieutenant governor. I think we had popular election put in there for our governors. There'd been electoral college before that, which Breckinridge disliked because a friend of his had lost, I think, to Governor Garrett. But that was a big event, that 1799 Constitution. And Nicholas gave a long speech, 2.5 to 3 hours, it sounds like, from what I could read. And he passed away within a few days. So he was probably one of the most overlooked persons I think I've ever run across. And there's Bob Stevens, Kentucky's Chief Justice, who is the person that so often used these clauses by Jefferson and tell for pages and paragraphs about the history of Jefferson and his involvement in writing these clauses and how the General Assembly waited on the clauses that he'd put together that Nicholas and Breckinridge went to get. You wonder sometimes how much of it is accurate, but I think we've come to a place where it's evident from the papers of George Nicholas, but he was certainly mindful of Jefferson's thoughts and dictates on what should be in our state constitution. And there's a portrait of Jefferson when he was 78 in 1821. He passed away 5 years later. And this down at the bottom is the second biggest gathering of governors in the nation's history. The only other larger gathering was by a collection of former governors of Virginia, I think in the 1980s. But this is a discussion on whether or not we should have constitutional reform in Kentucky and call a constitutional convention. It was a fun but a bit of a raucous dinner. I'm back there in the back there taking notes with Crit Llewellyn, Secretary of the Cabinet, who went on to be state auditor and lieutenant governor. And there's Governor Brown and Carroll and Louis Nunn and several others there in that photo. But we were advised by Governor Breathitt that he had been down that road in the 1960s and with Governor Weatherby, and trying to have a constitutional convention was very difficult. We had some provisions in Kentucky's constitution that required it to be put on the ballot twice and passed twice by the General Assembly. Breathitt told us that he decided to go around that because they had such a difficult time getting it approved, and he called a constitutional review commission that consisted of the Senate, members of the Supreme Court. They revised Kentucky's constitution, did a brilliant job, cut it in half in terms of its length, got out a lot of old provisions. It passed the General Assembly, and it was put on the ballot. The governors for the public's approval. It went to the Kentucky Supreme Court. Kentucky Supreme Court approved the process, said our Bill of Rights, which ultimately puts power in the people, overrides these other provisions that were in the old Constitution that required all these machinations. And after all that, it was defeated about 520,000 to 180,000 votes. It just went down the tube. So we were advised by somebody who'd lived it, if you want to change the Constitution, to try to do it by the amendment process. You can do every session no more than 3 amendments. And that's, I think, something that came out of this, I believe, was uh, annual legislative sessions. Any event, there's the author on KET with Renee Shaw, and there's the book. And that's sort of the extent of the presentation, but we could take some questions, or I could certainly chat some more if anybody would like to cover some other topics on it, James.
Yeah. Thank you so much for sharing all this information. It's super fascinating, sheds a lot of light on a lot of the new things. If you do have questions, this is a time that you guys can ask them. Just ask the question in the question and answer box, and we will address it.
Yeah, we'll do our best. Appreciate anybody that listened through all this.
So, with your research process, did you spend most of your time with those University of Chicago papers? What other and the different family papers? What all was your process for this research?
Well, there's a lot of material, particularly in the papers of John Breckinridge, and there's a good deal of scholarship, particularly by some University of Kentucky historians. Henry Dupree was one who wrote a fascinating article in the Kentucky Historical Society Register, James, in 1941, and it's an excellent story on the politics of George Nicholas, and that sort of got me into the thinking about Nicholas. For example, at the Virginia Constitutional Ratification Convention, he mentions that, and he has some footnotes to the debates, and that was sort of my hook to get into that whole process and realize something that had never crossed my mind. That's what a big deal Nicholas was really to the fate of the nation there in Richmond, and that got me into reading the debates, and I saw, my gosh, that guy is the floor general. He's the founder of Kentucky's first constitution. Is the guy right in the crux of the whole problem there, of just barely getting the Constitution approved. Lowell Harrison's works were very helpful. He wrote a wonderful book on John Breckinridge, biography. He wrote a series of articles. Some of them were in the Kentucky Historical Society's journal and the Register at the time. He wrote 4 or 5 of them. Then he sort of turned them into into a book. Papers at the University of Virginia, Wilson Carey Nicholas's papers. I found some interesting letters there from Nicholas to him, and you'll see them reflected in the book, in the letters and the chapters dealing with the Alien Sedition Acts and how he's sort of the go-between and shuttling around different versions of the Kentucky resolutions in Virginia between Madison and Thomas Jefferson. But there's a lot of it's a lot of material. I think for those that read the book that are interested in it, be sure to read the endnotes. They started out as footnotes. We ended up having them as endnotes at my publisher's request. There are about 125 of them, but I tried to have a lot of interesting history and material in those, but takes a lot of time to read through the material. But it came together.
Yeah, that's super cool to hear and great to see, and I think a great resource moving or getting to learn more about Kentucky's earlier history. We haven't had any questions, so I think that we're going to call it good. So thank you all to for attending this and spending your evening learning a little bit more about Kentucky's history. If you guys are interested, we've got always more different events going on at the Historical Society, both virtually. Oh, I see a question. Oh, comment. Um, okay, yes. So Anna says thank you. Very interesting. So thank you for asking or talking, joining us. Thank you for attending. And if you want to stay up to date, we've got events page that we've got a lot of other things going on all the time, Kentucky history related. So thank you all. Have a good evening.
Thank you, James. Thank you so much. And thank you for the to the society.